Here, sorry, just
Oh,
having technical difficulties on my phone, and the house is being painted and I'm
oh,
going to be in and out. So
that's okay. Join the
take
crowd
no
on the
offense.
technical.
Yeah, just ignore me. It's nothing personal if I don't get right with you or whatever.
That's perfectly fine. Thank you so much. And thanks for joining with us this morning. We have kind of a small panel for the Constitution as core. As some of you may know, we had a couple of other panelists, but they have, for various reasons, not been able to join with us this morning. And so it's down to Casey Wheatland and myself. And what we've decided we would do is that we will both read, or I'll read my paper and then Casey will read his paper. And then we'll open up for kind of discussion beyond that point. We probably are unlikely to stay here for 2 hours. We can if you want, but my guess is probably an hour will be, yeah, Tuan is saying no. So that's good with Tuan. So I just a very brief introduction about myself. My name is Michael Dittmore, and I'm a professor of English at Pepperdine University. Although I taught in our Great Books program for many years, I haven't done so for the last, I guess, 8 or 9 years, at least not in a full-time way. My academic specialization is in early American literature. So I'm not a political scientist. I don't have a law school background. I don't come actually from directly a history background either. So, and I keep trying to tell people this when I go to conferences and elsewhere. I try to approach the Constitution as an English professor, which is an awkward kind of thing to do, but you'll see this in the course of the paper, I think, as well. So I'll begin with my paper, which is titled "The Constitution, an Unevenly Destabilized Text." Obviously, an English professor title. The text, or the text, of the United States Constitution, considered more or less stringently as a text, poses a couple of hermeneutic conundrums. Here's one. On the one hand, the Constitution is widely celebrated for being a compact, written/printed, publicly accessible, single document. On the other hand, its own text in Article 5 carefully describes multiple procedures for modifying the text itself, I think, with the result that there can be multiple indefinite, temporary successive Constitution texts, either 17 or 27 at present, depending on how one counts, each one presumably requiring different collective and or institutional part-whole adjustments for hermeneutics, all without ever modifying the existing text itself, but only by adding more text. We would be going only a little too far, I'd say, were we to characterize the Constitution metaphorically as a choose-your-adventure text, closed in one way and open-ended indefinitely in another. Now, a second hermeneutic conundrum concerns the means and meanings of reading the Constitution text. On the one hand, the Constitution was, I believe, deliberately designed to be easily decoded by anyone fluent in the formatting of English language print orthopraxies prevalent in 1787. In other words, the same literacy and skills required to decode any other text, from a recipe for boiling eggs to Finnegan's Wake, whatever's in between. Those skills are transferable to the Constitution. On the other hand, the Constitution is hardly one more text among other texts. At least in certain contexts and applications, its authoritative reading can have profound existential impacts and implications locally, nationally, globally, and generationally. What then might we as teachers expect when we assign our students to read the Constitution from cover to cover? Or would we assign them to read in that way? What text do we select? And what kind of reading is that? Bear in mind that some elements of the Constitution's text do indeed read like recipes or instruction manuals or contracts, which we don't typically assign for close interpretation because there's little textual room for disagreement when it comes to the number of federal legislative chambers. We have a House, we have a Senate. While others, say the necessary and proper clause, might be wildly controversial. But classroom discussions, I would say in this case, have zero existential entailment, regardless of how they land. With these issues in mind, I'd like to give attention briefly to Article 5, the article that in a single welded together 142-word sentence provides for the Constitution's own mutation, or metamorphosis if you're a progressive. Most of the discussions of Article 5 I'm aware of focus squarely on procedural issues or abstractions like unamendability, but I'd like to offer 2 points for departure. The first is limited solely to the text itself, and the second goes to the very first amendment practices in 1789, which is in no way part of the text. First, as to the text itself, it might not be especially difficult to map or diagram, quite literally, the Article 5 procedures. And in fact, it would be easier to understand as a map or a diagram, quite literally. There are 2 modes of proposal. There are 2 modes of ratification, with 4 possible combinations. Then there are 2 exceptions, one temporary and the other permanent. We'll simply note further that one of the 4 proposal and ratification of the 4 combinations I mentioned, only one, the 2/3 of Congress and 3/4 of the state legislatures, has been followed with one single exception. And 2, the 1808 exception, in fact, has expired. So far, so good. And it so happens that this Article 5 description has functionally worked as designed. If it were a recipe for, say, cornbread, we could say, let's butter it up right now, except for those who dispute its design. In other words, that its supermajoritarian requirements are simply too difficult to meet. And yet any close reader, the kind that follows recipes or instruction manuals or contracts exactingly, should be able to tell us that Article 5 is woefully incomplete in several regards, not from ambiguity or from vagueness, but simply because it's incomplete. First of all, Article 5 does not explicitly describe the forms that amendments might or might not take. And 2, the Article 5 does not describe explicitly what should happen with these legitimately ratified amendments. I am sure that the spirit of Chief Justice John Marshall is roused to remind us that it is a constitution we are expounding right now. He's probably not happy with this. So as to the first point, this is going to sound very absurd because it is. Could an amendment take the form of a rebus or a wordless diagram, a gesture, a bird call, a joke, a poem or a story, a recipe or an instruction manual? Could it be written in French or Mandarin? Could it be on YouTube, etc.? In short, why can't we have a Dadaist constitution? And yes, I know we can't. Okay, so I'm not going there. But why? Perhaps the most basic reason is an inescapably originalist one. That in 1787, the word amendment, which was borrowed for this document, among lawyers and legislators referred to alterations made in legislative documents and other legal instruments in the same medium, format, and language of the original document, without it ever having to be said so, with some variability. An amendment generally had come to be regarded as a particular chain or block of textual material in emulation and correction of the document which it amended, so that there would be a textual seamlessness between them. But the second question is more consternating. Supposing we know, as we've established, the form of an amendment, and suppose we have just one stray legitimately ratified amendment laying around, a small one. Then what? What do we do with it? Does the closest possible reading of Article 5 provide explicit directions, guidance, or instructions? To get at this question, let me hypothesize 2 especially adept close readers. And for the sake of simplicity, I'll designate the first reader as James Madison. That should be easy to remember. And the second is slightly less so, Roger Sherman. Let me further stipulate that not only are they adept close readers, but also that they were so intimately familiar with the Constitution's text as both to have been present at almost the entirety of the Philadelphia Convention that produced it, and were signers of the final submitted document, and were even promoters of its adoption. What 2 close readers could have been better positioned to know exactly what to do with our stray amendment. For instance, would a legitimately ratified amendment have to be physically included with the rest of the physical document each time it was reproduced? But if so, would it have to be formatted uniformly? Could it be in a different font size, ink color? Could it be printed sideways or diagonally? Now, we know the answer. All we have to do is take out the pocket constitution from one of our own pockets. I assume you have one handy. And we will surely see the very same formatting arrangement we've always seen in every copy we've ever consulted. At least pretty much so, if we don't scrutinize too carefully. But even so, will we as close readers be able to provide exact textual support for this state of affairs? Failing that, though, can we as close readers then provide extra textual support? Let's imagine wildly now, like Madison and Sherman don't know what we know and take to be both legitimate and natural. And they have much, much else on their agendas. What then? If you're familiar with this story, Madison, who felt obligated to shepherd amendments through in order to attain ratification, assumed from the get-go that the proposed amendments he had culled together should first be formatted and stylized in emulation of the original, and second, that they should be interwoven or integrated into the existing text in very specific ways, to the point of removing some text and replacing it with other text altogether in some instances. And in fact, the specifics of that proposal were published in the New York Daily Advertiser for June 12, 1789, so that it was now a matter of public discourse. But on Thursday, August the 13th, as the House Representatives formed into a committee of the whole to consider that proposal more carefully, Sherman, a fellow Federalist, objected to the editorial placement. Perhaps this was merely a disingenuous stalling tactic, but it certainly triggered such a delay as representatives lined up on either side of the issue, despite claiming that form was far less important to anyone than substance, but also refusing much to budge on the matter. As the House continued to debate the proposal for the next week, Madison's interwoven mode stood as they began wordsmithing and chipping away at the various parts of the amendments we will come to know as the Bill of Rights, until the following Wednesday, when Sherman again introduced the motion to supplement rather than to interweave, and he won this time. And that was that. The die was cast. An adventurous path was chosen. From that moment on, the amending process for the United States Constitution has followed this mostly unstated editorial precedent. Many commentators reflected on some of the consequences and implications of this congressional agreement, which, by the way, did not itself apparently require full-on Article 5 processing. As Kenneth Boulding put it, quote, actually the change set a precedent for isolating amendments, broadened their role in constitutional law, and made it possible to point to a body of amendments known as the Federal Bill of Rights. As many commentators have pointed out, it makes them effectively look like the Ten Commandments because of where they are and how they're assembled together. All because of a post facto editorial decision suggested by Roger Sherman. But if I may add a supplement myself, there's one other textual matter left to consider, one as far as I can see entirely overlooked by commentators. First of all, the precedent set by this House vote to supplement rather than to interweave amendments does not appear to be any more binding than any number of other precedents that might be considered and overturned. There is, as far as I know, no reason why all the succeeding amendments had to be treated the same way. In the case of the first 10 amendments, supplementation made a certain amount of sense because they did not necessarily directly address particular elements within the existing document. I would argue with myself in that point, but for right now, I'm going to stay with that. But the next two amendments, the 11th in 1795 and the 12th in 1804, did exactly that. They went to very particular places in the existing Constitution. And that happened within 15 years of the first 10 being ratified. I confess I've not explored the House and or Senate debates over those amendments, but this would be a good question to consider. But even if they did not consider the editorial placement matter, the precedent would still be forceful, but not necessarily binding. And this leads to a second point. In none of the amending process, as far as I'm aware, has there ever been a motion to clean up or modify any of the existing wording of the Constitution, no matter how much a later amendment may nullify or repeal a particular provision. And thus, readers of all kinds, in some cases, are in the peculiarly complex hermeneutic position of seesawing back and forth between original and amended wording at greater or lesser distances for what is most currently operational and authorized. As a case in point, just how odd this textual situation can be, consider two other hypothetical readers. This time, readers who have committed not really to silent reading of the Constitution, which I think is the established and preferred mode, but its oral public performance. One reader I'll name Bob Goodlatte, who determined to use a superseded text for the script. In other words, a text that silently omitted those textual passages in the Constitution superseded by amendment. Followed, after a long succession of not quite inept readers, by one Mazie Hirono, to whom by chance fell the task of reading the errata of the 1787 engrossed parchment by Jacob Challis. I can only say, folks, you can't make this stuff up. That's just crazy to me. Some or all of which points, I hope, toward complexities of any reading of the Constitution that is in some way not merely a dumb recitation of the authorized words in their proper order and sequence with their punctuation as well, but one that's also, let's say, not a Supreme Court level of authorized reading. All right, I will stop there. I would invite some discussion and comment thoughts about that later. Casey, on to you.
Great. Thank you very much, Michael. We'll see if my internet connection survives this. My name is Casey Wheatland. I am a PhD candidate at Hillsdale College in political philosophy and American political thought. Political philosophy is my first field. I'm writing a dissertation on Niccolo Machiavelli, and the American founding is sort of my second field. And I am also a incoming Publius Fellow at the Claremont Institute. My paper is an introduction to Alexander Hamilton's political epistemology in the Federalist. Scattered throughout Alexander Hamilton's contributions as Publius are statements regarding the nature, limits, and origins of political knowledge. These statements are brief and many are easily overlooked. The reader may be led to assume that Hamilton eschews abstract reasoning altogether and looks to history and empirical facts as the only secure sources of political knowledge. Indeed, Hamilton's first statement about political knowledge is found in the very first paper of the Federalist, wherein he suggests that men lack the prerequisite knowledge to construct a sound political community from reflection and choice, and are forever destined to depend for their political constitutions on accident and force. Hamilton shows skepticism of the collective capacity to reason about political affairs and suggests, at least rhetorically, the possibility that political society cannot be founded on man's rational power, but only by a non-rational series of historical accidents. He recognizes and even emphasizes the dangers over-extraction poses to good politics. However, he does not abandon all abstract thinking, nor does he abandon hope that by reflection and choice, the modes and orders of a good political community may be formed. That statesmen and citizens alike ought to possess practical and factual knowledge, there can be no doubt. However, according to Hamilton, man's capacity for self-government actually begins and rests upon the ability to recognize pre-political truths and engage in non-empirical axiomatic reasoning. Hamilton's most extensive comment on epistemology in the Federalist is found in the first half of Federalist 31. He briefly pauses his discussion of the general power of taxation to cover a subject more universal and abstract in nature. All inquiries, he states, contain certain primary truths or first principles, upon which all subsequent reasonings must depend. These are self-evident truths or axioms that contain an internal evidence which, antecedent to all reflection or combination, commands the assent of the mind. Before relaying any political axioms, Hamilton lists some of the basic axioms of Euclidean geometry. Two things equal to the same thing must be equal to each other. Straight lines cannot create an enclosed space. All right angles are equal to each other, and so on. He then submits what he considers to be some basic axioms of moral and political reasoning, and I quote, that there cannot be an effect without a cause, that the means ought to be proportioned to the end, that every power ought to be commensurate with its object, that there ought to be no limitation of a power destined to effect a purpose which is itself incapable of limitation, end quote. There are other political and moral axioms, says Hamilton, that are not quite axioms. There are other political and moral truths that are not quite axioms, but are so obvious and attainable by common sense that they approach that classification. Of the 5 times that Hamilton uses the term axiom in the Federalist, twice are qualified uses referring to specific truths that only approach but do not quite reach the level of an axiom. In Federalist 6, for example, he states that it is a sort of axiom that neighboring states are natural enemies of one another. This cannot be a true axiom because it is not a first principle of reasoning, but rather a conclusion reached from long observation. Nonetheless, experience suggests that it is as true as if it were an axiom. In Federalist 28, he claims that it may be safely received as an axiom in our political system, that state governments will prevent the national government from using the military to usurp power. This is not technically an axiom, for its validity is not universal, but Hamilton wishes for it to be accepted as if it were an axiom in the limited context of American politics. And so when Hamilton uses the term axiom without qualification, as he does here in Federalist 6 and 28, he seems to be referring to rules that are universally applicable to all successful political systems. Hamilton compares geometric and political axioms to shed light on the groundwork of political knowledge as well as its unique limitations. By comparing politics to geometry, one sees that many political truths can be reached through abstract reason. Simple common knowledge is sufficient for recognizing that all effects have causes, that means and ends ought to be proportional, and so on. From these simple truths available to any clear-thinking person, the basic outlines of a political system can be formed, just as Euclid's axioms determine the outline of his system of geometry. Throughout the Federalist, one can see examples of how Hamilton applies axiomatic reasoning to his defense of the proposed Constitution. For example, he argues in Federalist 23 that limits should not be placed on the national government's ability to raise armies and build fleets to provide for the common defense. It is impossible to have foreknowledge of what threats America will face. Artificially limiting the government's means of providing protection could mean that it does not have the ability to fulfill its end. Hamilton's argument, quote, rests upon axioms as simple as they are universal. The means ought to be proportioned to the end, end quote. Hamilton steps back even further in Federalist 30. To raise an army, the government needs funds. Whatever level of revenue is needed to raise a sufficient army depends upon the size of the army that needs to be raised, which depends upon the potential threats that the nation faces. Therefore, the government must be given broad powers to raise funds, or else it might not have sufficient means to fulfill its end. This brings us to the limitations of axiomatic reasoning for political knowledge. Hamilton is not proposing that one can form an entire political system from axioms, but only the basic outlines of a system and a general orientation of political thinking. After all, if an entire system could be easily formed from axiomatic inquiry, then there would be little need for Hamilton to convince his opponents of the soundness of his arguments. The validity of the Constitution's framework would be self-evident. There are 2 problems which limit man's political knowledge compared to his geometric knowledge. The first is the influence of the unruly passions of the human heart. Nobody has ever killed over mathematical disagreements. Likely no one has even developed deep hatred of another over disagreements in geometry. You can tell I'm not from a mathematics department here. Politics, on the other hand, can never be detached from the non-rational and spirited elements of the human soul. When it comes to political judgment, the mind can become clouded by strong interest or passion or prejudice. It is difficult to remain an impartial judge in one's own case. Interest can sway the mind from proper reasoning. Honor, pride, or caution can also act as barriers and stumbling blocks to political knowledge. The second limit on political knowledge is that the principles of moral and political knowledge do not generally have the same degree of certainty with those of mathematics. Geometry deals with objects of the mind. Straight lines and circles are inventions of reason. Their certainty is absolute. Morality axioms cannot guide the science of politics as perfectly as they can the science of geometry. They provide broad universal rules of reason and action, but those rules are too broad to indicate precisely and at all times what actions are imprudent or immoral. Public reason can encounter serious deficiencies. As Hamilton writes, "It is a just observation that the people commonly intend the public good. This often applies to their very errors. But the good sense would despise the adulator who should pretend that they always reason right about the means of promoting it." Axiomatic reasoning can only take one so far. Take, for example, we'll go back to the question of raising armies and acquiring revenue. By non-empirical axiomatic reasoning, one can conclude that the means must be proportioned to their ends. It would be wrong-headed to limit a government's ability to acquire arms and revenue when such limits can prevent the government from fulfilling its most basic end, that is, the protection of the governed. But is this sufficient to know what kind of arms ought to be procured, whether to rely upon professional soldiers or citizen militias, how to best construct and maintain fleets, or even how to raise revenue without ruining the nation's finances? No. To answer any of those questions, one must move beyond universal axiomatic reasoning to reasoning about particulars through observation and historical study. One would have to be acquainted with topics as diverse as the revolution in the system of war sparked by modern finance and industry, the proper placement of dockyards, arsenals, and naval fortifications, and thorough knowledge of the principles of political economy and the business of taxation, topics that Hamilton takes up in Federalists 8, 24, and 35, respectively. These objects of inquiry are too numerous and in many cases too complicated to be grasped by the general public. To understand them properly requires leisure and thorough acquaintance with history, geography, and current affairs. Even these forms of empirical knowledge, Hamilton and Aristotle would both agree, are no substitute for real experience in the art of statesmanship. Many have thus concluded that Hamilton and the Federalists more broadly is anti-democratic, elitist, and fundamentally suspicious of the capacity of the people to rule themselves. That the authors of the Federalists oppose direct democracy is too obvious to merit comment. The influence of strong interest, passion, and prejudice is simply too strong upon that form of government. However, for any government to be justly established, it must be by voluntary compact between the rulers and ruled, because no man has the right to govern others except by their own consent. And that is quoted from Hamilton's The Farmer Refuted. The Constitution of the United States establishes a republican form of government which derives all its powers directly or indirectly from the great body of the people. The people are the ultimate source of authority and sovereignty. The fate of the republican form of government ultimately depends upon the ability of the people to rule themselves through their constitutional form. In this sense, Hamilton's political epistemology is not elitist, but republican. It begins with geometry, a non-empirical and even pre-political mode of study that can be known to any person of sound mind. A mere school child can be taught its basic axioms, which require nothing more than clear thinking. Anyone that can come to recognize that all right angles are equal, or that the whole is greater than the part, can similarly recognize that there can be no effect without a cause, or that means ought to be proportioned to their end. This is the beginning of self-government. From these axioms and the discipline they impose upon the mind, one can inquire into the more particular and less certain realms of political knowledge. So long as the Commonwealth writ large is acquainted with universal axioms, the judgment of its members is not too clouded by interests, passions, or prejudices, and it can find enough men of talent and intellect with the requisite knowledge of its particular political circumstances, there is hope that it can operate by reflection and choice. But of course, one must not have too much hope. Although these axioms are simple, they are nonetheless a standard of knowledge that not everyone will achieve. This political epistemology is republican, not democratic. There is a distinct possibility that the stock of citizenry will be too poor of quality or education to attain even the most basic geometric and axiomatic knowledge. In such a case, if Hamilton is correct, self-government is impossible. And I will stop there and open to question and comments and throw this back to Michael.
I love that. That was great. That was fascinating. If I may ask a question, maybe just to start at one point. As you were speaking, I was thinking of two people in particular that I thought fall somewhat into his camp, but also one of them winds up being an enemy with him. And I know this is asking you to go outside of what you were doing. What you did was great. Thomas Jefferson seems also in some ways to be committed to certain Euclidean kind of axiomatic approaches as well. Any thoughts about Jefferson is in relation to Hamilton on this?
Yeah, Hamilton has a great line on Jefferson there, and I don't remember where it comes from. I think it's from one of his letters, and I don't remember to who. But he describes Jefferson as this radical who tries to instill too much geometric form onto politics. And so Hamilton and Jefferson would both agree. Obviously, you need to have some understanding of axioms, the sort of clear basic thinking. But Hamilton says, no, Jefferson goes too far in that he rejects, to a certain degree, the need for historical study and the need to see that human action is too imperfect. It is too unpredictable to be perfectly directed by these axiomatic forms. So that's Hamilton's response to Jefferson. And although Jefferson too, he has his own use for empirical study and historical study, and he ends up coming around to certain things. For example, the need for manufacturing and commerce and a strong navy, that Hamilton is saying from the beginning, yeah, I knew this basically from axiomatic reasoning.
Very, very good. Well, let me open it up to everyone else who's joined with us as well. I think we have Jenna and Jamie and Stephanie, Jacqueline and Tuan for comments, thoughts.
I have a question on your paper too, Michael. I can start.
Certainly.
When you're talking about the mode of writing an amendment and how it isn't clear, there's a lot of leeway that we have, and we could do all these different things. You could write a poem for an amendment. And of course, that wouldn't make too much sense for law. But Plato in the Laws actually suggests that, saying that our laws should have preludes to them, something like songs that inspire the citizens and persuade them, open up their minds a bit towards understanding the law and accepting it in their heart. What would you think about that? Of, say, taking something like the 13th Amendment and applying a prelude, maybe something like Abraham Lincoln when he writes that, as I would not be a master, so I would not be a slave, right? That's his understanding of Republican government. And in a certain way, that kind of opens up the amendment to the sort of broader, more formative way of interacting with the human soul.
I like that idea. And I guess my first thought about that is, in some sense, the Constitution does have that, not amendment by amendment, but the preamble serves that function. And I was thinking that apart when you were saying that, I've recently been assigning in one of my classes speeches by Frederick Douglass that I've never signed before. And I always knew that Douglass had this difference between William Lloyd Garrison over abolition, but I never got into the details of it. What I found fascinating about Douglass and his changed attitude toward the Constitution is, in a way, he uses the preamble as the key to everything, right? And probably because the preamble makes no reference whatsoever to slavery in a way that's excluded from everything else that you see that follows. So in a way, the preamble and the funny part about saying that too, I think, is this. I don't know if any of you who were listening to that part of my talk toward the end of it about Bob Goodlatte and Mazie Hirono understand what I was referring to, that the House of Representatives began this public reading of the Constitution on the House floor back in 2011. And to me, there's several kind of things that happened in the course of it, but one of the awkward things was that Mazie Hirono actually did wind up reading the errata from the gross parchment, which makes no sense to me. I don't know why they would do that. But reading the Constitution aloud as an oral document, I've had a hard time thinking that through. Right. For example, when you think of the Federalist Papers, I don't think of this being oral, but there's a voice to those. And I love picking up that in the Federalist Papers. It's more difficult to pick up a voice in the Constitution, except for the preamble. And the preamble does have that kind of function, I think, to give this kind of glorious poetic opening to the rest. It's the one part we would tend to memorize. But that's a great, great point. I hadn't thought about that as you can proceed throughout the rest of the document. Yes.
Yeah, that's great.
Michael, I had a quick question, but unlike Tuan, my vaccine from yesterday has hit really hard, so I'm a little bit nervous about not articulating it well. Did you say that the Constitution does or does not state that the language within the body can be changed? The non-amendment part.
The Constitution doesn't say anything, and as far as I know, there has never been any congressional effort to clean up the language of the. I mean, here's the reason why I'm saying this.
Mhm.
If you read the Constitution in Article 1, you will come to the 3/5 clause. And
Mhm.
depending on which constitution, I have several pocket constitutions here.
Mm.
Depending on which one you have, some printings of it won't say anything. Some will put things, will kind of like strike through. Some will put brackets around it. Some will put a footnote to tell you that that's no longer functional, no longer operative.
Hmm.
But technically, that language remains. I don't know of any attempt that's ever been made officially within governmental spheres to remove or modify any of the language, no matter how it's been amended later on. And that's true. Another kind of example of this, and I'm terrible at remembering the numbering of each one of the amendments. I'm just not that good. But here's another example. When the House read the Constitution from beginning to end, because they were reading a superseded amendment, they skipped the amendment that established prohibition. But they read the one that repealed the amendment that established prohibition, which I still, my head still doesn't quite figure that out now very well either. But nonetheless, that gives you kind of an idea that somehow the previous amendment has to stay there so the later one can kind of be functional in a different kind of way, if that makes sense.
That makes sense in a legal sense and a historical sense.
Well, that's one of the arguments about this, the way it's done, is that some people argue that in a way, if you read the Constitution from beginning to end, you're in some sense duplicating the history that was there. Now, you also
Right.
leave a lot of history out at the same time, but that is a very interesting kind of way of thinking about how you might like the appended amendments rather than have them interwoven.
That's really interesting. I really enjoyed your talk. Thank you.
I appreciate it.
I have a question for Casey, coming from someone who is very far away from, any meaningful sense of being a specialist on the Constitution. But you don't mind, like, I know your paper, right, is about axiomatic truth, right, not empirical, and so on. And I appreciate it. But do you might explain a bit more about Hamilton's view of empirical truth, right? I mean, he's interested in historical precedents and facts, right? And he thought that they are more sure-handed as guiding, so to speak, ways to approach political knowledge and so on. Like, did he, how did he conceptualize that? I mean, are there terms that he used when talking about them?
Yeah, that, and he uses basically plain language to describe these, right? He will talk about historical study, or he doesn't use any sort of technical philosophic terms. And so I try to avoid them as much as possible in this presentation, right? He never uses the term, as far as I can tell, a priori or a posteriori or anything like that, at least not in the Federalist Papers. And he, people will often compare him with David Hume in Hume's understanding of epistemology, especially as it relates to politics, right? Because Hume is also very conservative in the sense of, well, we don't want to have too many abstract formulas. We want to ground everything in precedent and growth and history and so on. But I think a better model, and I just thought of this, so maybe it doesn't work, would be Blackstone. And Hamilton read Blackstone's Commentaries on Law very carefully. And Blackstone, of course, he's the common law man. So he's also concerned with historical study and seeing how things actually work, experimenting. But Blackstone actually begins with axiomatic reasoning as well. Hamilton derives his understanding of natural right, of equality, and all these things from Blackstone. Well, perhaps that's not true. Perhaps he doesn't. I don't know if that's true or not, but his understanding is certainly very similar to Blackstone's, and he quotes Blackstone extensively on that in The Farmer Refuted and elsewhere. So Blackstone's a way of approaching law and politics, and the relation between axiomatic reasoning on the one hand and empirical knowledge on the other, I think that's a pretty good way to approach Hamilton's understanding.
If I may follow up that in a different kind of way, I'll throw a term out for you to maybe, and I don't know if this helps to kind of get to that point or not, but a national bank. Good idea?
Yeah, that's a good example, because how does Hamilton arrive at the understanding of a national bank? He does so through extensive research into economic history and to various different economists, Jacques Necker, Adam Smith, all these different people, many who take many different approaches to economics as well. And so, but yeah, that's a great example of that's the national bank. Hamilton reaches that through, it starts with axiomatic reasoning in a sense, right? Because, well, we need, our means must be proportionate to the end. We do not have the finances to meet the end. Therefore, we need some scheme that will improve our financial means, right? So that lays out the problem. And then from there, he says, aha, a national bank. And here is everything I've read, all the historical literature, economic literature. Here's what I know about the finances of the country. And here's why that resolves this problem, which I have found through axiomatic reasoning.
Okay, but Dan, just one layer on that at the same time. That's very good. But he has to do that also within something like an existing constitutional framework, right?
Yes.
So he's got to figure out how a text is going to let him get to that place. So I'll throw that back to you at that point.
Yeah, and that's his understanding of the necessary and proper clause. And to be quite honest, I am not a common law guy. And so I tend to just accept Hamilton's understanding of the Constitution to the extent I understand it because I like it. But yeah, that, and actually his understanding of that is that, well, it would be absurd to have a necessary and proper clause that does not permit the proper means to fulfill the ends that are laid out in the preamble of the Constitution and the rest of the constitutional text. And so the way that he approaches that from the common law perspective is, well, we did not write an absurdity of a document. Therefore, we must interpret this in a reasonable manner that makes room for the necessities of politics.
Mm-hmm. Which fits very nicely, by the way, as you were speaking, I was thinking of the second national bank, the McCulloch v. Maryland case, when Chief Justice Marshall makes the very same, it seems to me, the very same argument about ends and means. Once we know what the ends are legitimate, they exist within where we are, we have to be open to what the means can be to get there. And so I think that works really, really well.
Yeah, that's the perfect parallel there. He's definitely has Hamilton's same understanding.
Yeah.
Casey, have you found like reactions from other founding fathers to Hamilton's, those short, brief points about three political truths? I mean, he's kind of like an unusual figure, right? In the sense that liberals and conservatives, so like both claim him and sometimes hated him. But and so I'm just curious on that point.
Yeah.
Scatter. you said this stuff is so scattered. I'm just wondering if anyone on either side caught some of it and sort of like responded to it.
Yeah, that's a great question. Not that I know of. I don't know of any direct responses to that. But what I have found is that many of the founders approach this sort of epistemological side in the same sort of way. James Wilson, in the first few chapters of his Lectures on Laws, also provides a definition of axiomatic reasoning and self-evident truths that is very similar to what Hamilton lays out in Federalist 31, which is interesting because Wilson is also a Federalist and has very similar concept of political philosophy. But this seems to be something common to the education of the founders generally. I think they all had this sort of sense of what clear thinking and geometry mean for political life, even if they disagreed on how exactly that relates to the particulars and to our own circumstances.
Casey, I had a quick question for you. You went off of, or you raised a question for Michael about this idea of poetry preceding an amendment or a prose document. And you're writing your dissertation on Machiavelli, and that put into, is that correct?
Yes, that's right.
So it put into my mind the end of the prince, and I'm looking at it now. Virtue will seize arms against frenzy, and the battle will be brief, for ancient valor is not yet dead in Italian hearts. This is the Oxford World's Classics edition. And so I couldn't help but just think about that relationship between poetry, that's Petrarch, poetry and prose, and ending on that note. And then the direction Michael went was talking about the preamble, which is a preamble. So I'm just, I don't know what the question is here, but you have thoughts around this area.
Yeah,
it's
funny you should point. It's funny you should point to that passage, because the last chapter of my dissertation, which is not yet written, is on the final chapter of the Prince. And my
I thought it
dissertation
might be.
generally deals with Machiavelli's interpretation of Girolamo Savonarola, the unarmed prophet from chapter 6. But yes, in that very final passage, right, Machiavelli ends his work with Petrarch, a modern, someone only 100 years before him, an Italian too, with a certain poetry, right? That's Machiavelli, I think, trying to shift people's spiritual horizons, trying to move them towards this sort of that's Machiavelli's way of doing what Plato says in the prelude in the laws about having preludes to your laws. See, I could go on about that for a very long time, and I will.
Well, if you want to give another paper on that, I'll come to it, because that was very, very exciting. And I haven't read Plato's The Laws, but I've been meaning to for a while. So this will be my homework now. Thank you.
Yeah.
Hillsdale has been sort of like, in my observation, Hillsdale, and especially natural students from Hillsdale, have been how to put it, like a springboard of papers on either the founding fathers or like Plato and so on. So I really appreciate this one. Yeah. But can I ask you, like since I didn't realize that you were working on Machiavelli, is there anything you found in Hamilton that that he borrowed or took off or whatever from Machiavelli?
Nothing directly that I know of. People like to compare Hamilton and Machiavelli often because they think of Hamilton as he's a realist. He is concerned with the effectual truth of the matter. He's not caught up in ideology. And I think people can take that a little too far, because Hamilton is certainly a moralist. He believes in natural rights and social compact theory, but he's very hard-nosed in the same way that Hamilton is. Now, the only founding father I know of who takes a lot from Machiavelli, and this is actually very interesting, is John Adams. John Adams writes a 3-volume work called Defense of the Constitutions of the United States, where he's defending the American political system from sort of foreign European political thought, and also defending the national constitution. And the second volume of that work, and like all of Adams's big works, they're always weird and go off on weird tangents, and he's fascinating, a very strange figure. But in that second volume, it's mostly a commentary on Niccolo Machiavelli, Francesco Guicciardini, and the Italian medieval communes and Renaissance cities and Renaissance tyrants. It's very strange. So he actually pulls a lot from Machiavelli, but so far as I know, Hamilton does not.
Michael, I know that you have given a version of this paper. I know it's not the same at all, right? At a constitutional conference. How was it received? I'm just curious.
It was a small group, but it went well, I thought. It was an interesting group because I had an advanced constitutional scholar who was 10 times over my head, and someone from Italy as well, who was kind of coming into this. So it was an interesting group that we had. I will say the constitutionalists, by and large, don't get terribly interested in textual editing types of issues, which is kind of like what I've been very much focused on with this, asking. I think for me, the biggest thing is imagining James Madison and Roger Sherman, who were there. They knew, I mean, they were as close as you could be, who immediately disagreed about how to actually add the amendments. Just surprises me to no end. Not that it's an enormous issue in certain ways, but the United States Constitution is relatively on the minority side with that in terms of world constitutions. Most of them have different ways of either interweaving or including the old material as well as the new material together, so you can see what the changes are. Or you have the British form, which is totally strung out in different kinds of ways. But yeah, so an interesting question about whether, I mean, and that goes back to a question too, what kind of effects follow on adding them on as we've done, if there are effects that we can kind of point toward. Yeah.
Thanks.
Can everybody hear me okay? Yeah, there we go. My mic wasn't working for a second. Apologies. Thank you both for your papers. And following this discussion has been quite fascinating. I was struck by, Casey, you pointed out, you pointed to the laws, of course, and you pointed to the way that the founding fathers, especially Hamilton, but others like like to read history to understand how to construct the republic. I was thinking, as you mentioned, some influencers of the fathers, founding fathers. I was thinking of Montesquieu, of course, who was arguably the most diligent of historians when it comes to parsing through the structures, the laws of other republics or any government throughout history. And I'm brought back to that idea of music and poetry. How can that work? As anyone who's read the laws now, I'm sure, but I'm sure you're aware, Plato is at pains to try and harmonize, maybe is the right way to put it. I don't know if harmonize or Sparta and Athens, right? Especially when it comes to music. So I just wanted to read from Montesquieu, who intentionally diverges from Plato, just briefly. Quote, in short, the exercise practiced by the Greeks aroused in them only one type of passion: roughness, anger, and cruelty. Music arouses them all and can make the soul feel softness, pity, tenderness, and sweet pleasure. So Montesquieu, end quote. Montesquieu saying the Greeks really were interested in music insofar as it might inspire warlike passion. And he's saying we don't want that. We want something more pleasant, more soft, more gentle. He emphasizes over and over again. So I'm just wondering, does that factor into the fact that I mean, again, I think that's an intentional sort of what's the word I'm looking for? Narrow reading or misreading, if you want to call it that, of Plato, because Plato doesn't just talk about music in one way.
Right.
But the governments, presumably, is what is Montesquieu's mean. Does that affect how the founding fathers might, if they, or Hamilton, maybe just stick with Hamilton alone, how he might understand poetry and how it might stir passions? Michael, your comment about stirring up the passions in the preamble especially brought this to mind.
Yeah, that's a great question. And you're right, Montesquieu is definitely misreading, probably purposely so, the Republic and the laws there. I can't speak much to Hamilton on that point. He's certainly, he's a big fan of Montesquieu. He doesn't quote him as much as people might think, so far as I can tell, but he has this great line in one of his essays, not in Federalist, but elsewhere, where he says that a government must fit its people like a cloak on a man, and that something that would work in Philadelphia would not work in Paris and could be absurd in St. Petersburg. And so he's very interested in Montesquieu, of course. I don't know that he has much to say about song or poetry. The founders generally, they're interested in that. The idea of patriotic music and song. I don't know too much about this topic though. What I can think of though, it's sort of martial. It's civic spirited. It seems to be actually largely leaning towards the type of music that Montesquieu is critiquing. That's all I've got on that.
I'm so impressed by this panel that no one at this point has said anything along the lines of "I'm not giving up my shot." It's kind of a joke there, an attempt for those of you who know the Hamilton musical that I don't know nearly so well, but some of you know that. You know, I will say one of the things, kind of add this in a slightly different kind of way. One of the oddities about the Constitution that struck people as they were going through the ratification process was not just that there wasn't a Bill of Rights, but where it would be located. In the state constitutions, by and large, the Bill of Rights that were located and the ones that had those actually preceded the Constitution. So going back to my point about how they could have done this in any number of ways, initially, actually, Madison did have more language that he wanted to add for the preamble that very much focused on the sovereignty of the people, right? That was one of the big issues they wanted to raise. That wound up getting voted out as they made this movement to appending the amendments some at the end. But, you know, actually, you could see, I don't think it would work all that well, but you could see the 10 amendments make up the Bill of Rights preceding the rest of the document, or maybe being in between the preamble and Article 1. Almost, I wouldn't say it's quite poetic, but there's a way in which there's something very rousing about that too, if that kind of makes a certain amount of sense. Yeah. I hadn't thought about that way. That helps me kind of see that.
That's really interesting, Michael. I did not know that Madison had more to say on for the preamble. Do you happen to know what exactly he said about sovereignty? I could imagine it'd be something like what he says in Federalist 39 about the great body of the people being the source of all power in a Republican government, or something like that.
The best of my memory, I think that's pretty much what it does. That's the reason I mentioned the newspaper publication, because that was in the pub, and not that it stirred a lot of comment and response, but early on with the House of Representatives, I mean, very much unlike the Philadelphia proceedings that had closed doors, when they were hammering their way through the amendments, that was being reported in some of the newspapers and spread across the nation. So there was some attention given to that in a certain kind of way. I think you're right. I'll have to go back and look at it to be sure, but that sounds about right. Because he was, at that point, Madison is trying both to placate all these people who want the amendments, but also to think in very practical terms about what will actually work, right? He's thinking a lot about in terms of what will get past the 3/4 hurdle across all the states. And so he's winnowing things down. But that, my memory is that is what he was doing there. I'll have to go back and find that though. But one last question for Casey, and not this way, a question exactly. As you're speaking, one of the founding fathers I've been thinking back to as you've been talking is Benjamin Franklin, who fits in an odd kind of way because he's the oldest revolutionary. He has a different kind of education, a very different kind of background in some ways from many of the others. And yet, he had studied math on his own, by the way, as well, on his way going through things like this. I don't know how well he fits in, and I'm just trying to think through that. I appreciate what you said earlier, that I think that generation especially shared these kind of common ideas about axioms and empiricism when it comes to political matters. And Franklin wasn't exactly a politician in the same way that they were, but any thoughts you might have about Franklin, if he fits well with this, or what do you think?
Yeah, I don't really know much about Franklin, to be honest. Not enough to really comment on it.
Yeah, I'm thinking about him in part because there's this very famous passage he has in the autobiography about how he became a vegetarian early in his life. And if you know the story or not. Yeah. And he says, it went on one time when I actually smelled this frying cod, and it smelled so good. And he says, a convenient thing it is to be a rational creature, because we can always find or make a reason for anything we really want to do, which kind of blows apart, everything about being fully rational in a way. But it's just a hilariously funny passage too. So I thought I'd mention that. Well, thank you very much. This has been fun this morning. I wasn't sure how well this would go. If there are any other questions or comments, I'd be happy to go around if there's anyone else who's got anything else they'd like to say though before we depart.
Oh, thank you to the both of you. I mean, I don't know if Jamie and Jenny knew, but basically there was supposed to be 4 people. But one of them didn't even know that his paper was accepted.
Yeah.
And
the other one being double booked, so he's going to speak later in the week, I think, as well. Yeah. Well, thanks very much to Dolan. Thanks for Casey. Thanks for all of you who attended. I appreciate this very much, and hope you have and continue with, by the way, the rest of the SCT conference. I look forward to seeing other elements of it as well. Take care.
Great. Thank you, Michael.
Very well done.
Bye-bye.